Hi, I'm John Dearie, and welcome to our face-to-face. Today we will be discussing an area of the law that frequently touches people and brings them with, unfortunately, injury and also a lawsuit. And we're doing this with a very experienced attorney in the personal injury field, and we are very delighted that she is part of our legal team here at the Dearie Law Firm, and that's Lindsay Harriman. And Lindsay, welcome, and delighted to be with you.
Thank you for having me, Mr. Dearie.
Good. That's the second time that you've used that expression, Mr. Dearie, but I'm liking it, believe me. No, John is good. Anyway, so we're talking about essentially a general topic in the law that's known as premises, but they're really categories of injuries when people either trip and fall or slip and fall. So let's really, by way of definition, let's sort of put a definition on both of them. Let's try a trip and fall accident.
Sure. Some examples of a typical trip and fall accident would be something like a defect on the sidewalk, a crack in the sidewalk, uneven panels, something in the roadway, a pothole in the roadway, a defect in a tree pit well, a defect in a pedestrian street ramp, when you're crossing onto the curb, sort of broken sidewalks, and to that effect would be considered a trip and fall.
What about a slip and fall?
A slip and fall is typically an accident that involves some form of substance. Be it when you're in the grocery store and you're walking down the aisle, something fell, you walk over it, you slip and hurt yourself. Or it could be something like a snow and ice case, an icy sidewalk, you slip, injure yourself. Or even something simple, if you're walking out of an apartment building, there could be a leak on the stairs and you slip on the water. That can be considered a slip and fall accident.
When an individual unfortunately is subjected to a slip and fall or trip and fall, we'll consider them both together for the purposes of our discussion. What do you recommend if they are not so grievously injured that they fracture, break a leg or something and are unable to move, but if they have that kind of an accident, what do you suggest that they do in the immediate aftermath of the incident?
So one of the first things that, if somebody unfortunately injures themselves, a crucial element is to take out that phone and snap a picture. It's very, very crucial to anybody's case. Due to the outstanding elements, if you're outside, absolutely, if there's something like spilled in a grocery store, if there's ice, due to the fact that somebody could come and try and clean it up, or due to the temperature outside, the temperature going up, and the ice essentially melting, it's very crucial to first try and take a picture. If you can't, it's not the end-all be-all, but it definitely helps your case. The next step is to contact an attorney and to seek medical treatment. And then the attorney will help guide you for the next steps.
How important would you say it is if someone does have a tripping accident and an individual happen to be standing there and sees the accident? How important is it to try to get that individual as a potential witness to the accident? How important do you find that to be?
That's also extremely important. In cases, there is the person that gets injured is considered the plaintiff. There's going to be a defendant in the action. There can be two different stories. Their stories might not be, they might not be neutral. What happens when a witness comes into play? That's basically an impartial, neutral party that could just say, they don't have any stake in the game, and they can actually give their observations of what happened, and they have no interest. So it's absolutely beneficial if you can get the name, the phone number, even potentially an address of that witness.
When you talk about a fall of this nature, what, based on your experience, has been the type of categories of injuries that people generally suffer?
Well, people can suffer something like, of course, a fracture, which is, a broken bone, but there also are, soft tissue injuries. If you fall and all of a sudden you have a lower back pain, that's still, even though it could be just soft tissue, it is still a viable injury. It is still something that, you could possibly obtain compensation for that.
How important is your experience with regard to a person has an experience like a trip or a slip and fall, has some injury to their back, their leg, wherever it may be? There's something that I think most people are familiar with, x-rays and MRIs. What do you recommend in terms of the ability of the medical profession to make the evaluation as to what the seriousness of the injury is?
Well, you know, what we like to tell our clients here at the Dearie Law Firm is that really you want to seek medical treatment as soon as possible in order for yourself to feel better, right? But also, once you seek that medical treatment, whatever these sort of diagnostic testing that they do, it also creates evidence of your case to help build your claim. It's extremely beneficial for yourself to get treatment, seek help to feel better, but also to build evidence for you to have a successful claim. So absolutely, we do not suggest any delays for your own health or for your case. Go to the doctor. If the doctor says, you know, come so many days a week for this amount of weeks, we ask that they do it and, you know, help to progress their claim and help to build their health.
I suppose in using the category and description as you did initially about a trip and fall, I think historically the overwhelming majority of those kind of cases tend to take place on the sidewalks in the city of New York and elsewhere, but talking about the city. Why don't you talk about what the liability issue is and who is responsible for maintaining the quality of the sidewalks in the city?
Okay. So if you're walking down a city street and you get injured on a sidewalk, for the most part, the liable party is going to be the adjacent landowner. So unless that is a city entity, it is then going to be the owner of the property, which could be a private entity. However, there are some exceptions. If the building that you fall in front of happens to be a 1, 2, or 3 family unit, then the liability will be on the city of New York. If it's not that, let's say it's a commercial building, or if it's a very, very large residential apartment building, then the liable party is going to be the owner or the operator of that premises, of that building.
You know, it's very interesting in terms of what has happened more or less in the last 15 years, roughly, because with that same kind of uneven sidewalk, defect, crack in the sidewalk, any of those kinds of defects that you've identified, up until about 2003, the city of New York was ultimately responsible. Mayor Bloomberg was quite effective in doing something that I personally know that a number of prior mayors attempted in the state legislature to get it passed, which is move the liability off the city of New York. And the mayor succeeded in doing that. As a result of it, while there was some frustration, nonetheless, the fact is that it is now in law. The city is not primarily responsible. What happens in the situation in which you have an adjacent landowner, not a 1, 2, or 3 family private homeowner, but an adjacent who does, for whatever reason, doesn't have insurance, seeks to oppose in whatever way without litigation per se? Is not the city then comes in to be primarily responsible and deal with that particular case, but then ultimately will seek to get compensation back from the adjacent landowner if there is a settlement of whatever value?
That would be the case, yeah. I mean, what would happen essentially is the city might step in and try and indemnify and step in the shoes of that adjacent landowner, compensate the plaintiff, but then the city will then go after that private entity, yes.
Now, you mentioned about the other major category, which is the so-called slip and fall. And by the way, just for individuals that may ultimately have a requirement for an attorney in terms of a trip or slip, the general category that lawyers talk about is called premises, as we well know. That means this kind of an accident. And my question is the issue of slip and falls. How does that differ, if it does, from a trip and fall as it relates to the type of both injury generally and also the liability?
Well, when we think about the big difference between a slip and fall and a trip and fall as far as liability, what we really are talking about, I think, is snow and ice cases. And there's a lot of determining factors. Snow and ice cases are not the easiest cases to litigate. We want to know when you come in, what time did the accident happen and what time was the last snowfall. We want to take a look at about 5 to 7 days in advance, the varying temperatures. Did the temperature go up? Did it go down again? Was there ability for ice to melt and then refreeze? We also want to know the location. Was there a maintenance company a snow cleanup company that would come in and clean up? Were they there that day? All these factors are completely contributing to the ability for us to litigate successfully a snow and ice claim.
There is no question that during the cycle of the year, when we do get into that, what I guess you say, January, February time period, and if it is a snowy winter season, that there is a substantial number of cases with ice and snow. And I think you touched on they can be difficult, and it's very important to note when the accident occurred and when the last snowstorm was. Just touch on that.
Absolutely. When people come in and when there is snow falling, there's certain regulations within the city of New York as far as when there is an ongoing storm. If you are injured during an ongoing storm, it is very, very difficult to litigate against the city or even a private entity. Both of these two possible defendants have they have a window, a 4-hour cleanup window, meaning that, certain plaintiffs can be barred if they fall during an ongoing storm. Let's say, the storm stops, the city and the state of New York, well, this is a city ordinance, they give landowners up to 4 hours to clean up the snow and make the area clean and reasonably safe. Also, if you fall within that 4-hour window, it's going to be a very difficult case to litigate.
Not impossible, but nonetheless very, very difficult, as you say.
That's correct.
It's challenging. Let's talk about a slip and fall, trip and fall kind of situation on a construction site. Now, I think based upon our face-to-face, people are aware that if there is a construction site accident, an individual is, generally speaking, with very minor exceptions, entitled to workers' compensation. But they might be entitled also to a third-party action. So without veering too much off into construction site accidents, if you have a situation where someone trips, for example, on a toolbox that's left by someone who is not your employer, so you work for company X and someone from company Y leaves a toolbox there that causes you to trip and fall, and let's say, for our example, fracture your ankle. That allows the so-called third-party action in a trip and fall case in a construction site setting.
Absolutely. So as you just mentioned, with very few exceptions, if you're injured on a construction site, you would have the ability to have workers' compensation. What we could provide here is something to litigate a third-party claim, meaning that even though you are getting separate compensation from workers' comp, you can still pursue a claim, a third-party claim, to go after a negligent defendant on a construction site, and we here have the ability to do that for you.
You mentioned something before about the importance of taking a photo, if you're able to, of the defect that caused you to fall. I think it's important to underscore for an individual, if this is the sidewalk and this is the defect, to take a close-up picture to give a good, or to take one that allows you to see what the height of the uneven sidewalks may be, is important. But I think it's important to stress to take a picture from away that allows you to see maybe a street sign or to see an office building or some address, so that persons looking at that can be able to tell where it is. It's not just, if you have just an uptight shot, it can't tell where it may have been on street Y or street Z.
Absolutely. When you're taking photos of a defect, you want to try and hit all identifying factors. Unfortunately, sometimes when people fall, there could be people everywhere and then there could be nobody around. So you want to be able to take a picture that gives perspective close up, far away, and then the environment surrounding it, so you are able to provide evidence that you fell where you say you did. Also, the importance of a photo. You come in and you discuss with your attorneys, and here's the photo, and we look at it together. But just, the potential plaintiff and us as their attorney are not the only individuals that are going to look and sort of evaluate this possible claim. There's going to be judges, potential juries, insurance carriers, and also other attorneys, the defense attorneys, that want to see and gain a perspective of the defect that you tripped or slipped and fell on.
Talk about the distinction between tripping and slipping in a governmental building. You're going to take care of some Social Security matter as contrasted to doing it in Walmart or some other private location.
Absolutely. If you are, let's say, in a municipal building, maybe a city hospital or a post office or something like this, and you become injured, it is absolutely necessary to contact an attorney as soon as possible. And the reason for this is that you have a requirement to file something called a notice of claim within 90 days of the accident, and your attorney will be able to do this for you. It is a requirement that you put the city on notice of the accident. Also, it plays, whether you fall in a municipal entity, it plays a part in the ability and the timing to file suit.
What is that timing and difference to file suit? Because that, I think, is important for people to have in mind, the difference between a so-called governmental potential defendant and Walmart in our example.
Good example. So if you fall in a store like Walmart, the statute of limitations, which is the amount of time that you are given to file a claim, is 3 years. However, it's very, very different if you fall on municipal property. You actually only have 1 year and 90 days to file that claim. There are very, very strict regulations that go a part of this, and there's very few exceptions. If you miss these deadlines, it's very, very difficult to pursue a claim if this occurs.
You mentioned before, and I think it bears underscoring, the so-called notice of claim. Why don't you touch on that, including the time period from the date of the accident?
Sure. A notice of claim is a document that's required that is filed with the city. It is basically the who, what, where of an accident, and also the importance of those photographs. If they exist, they will go along with this document. The document must be filed within 90 days of the accident.
And if it is not?
If it is not, with very little exception, unfortunately, the plaintiff's claim would be barred.
We have a lot of people in the general New York area, New York State, city, etc., that are here with immigration-related issues and are out of immigration status. If any of them are in a slip and fall or trip and fall incident, are they entitled to bring a legal action?
Absolutely. Your immigration status has no effect on your ability to make a claim due to these kinds of accidents. If somebody feels unsure about this due to their status, they shouldn't hold back from contacting us and coming in and discussing the matter with us. They still, just like anybody that was, has a citizenship or something like this, they have the same rights to pursue a claim.
You mentioned about someone coming in and discussing the case with you. I suppose we would call that the initial consultation, where the individual is explaining what happened, what the injuries were, what the treatment was, how the accident occurred, etc. Talk a little bit about what you are looking for as the attorney in that initial intake kind of meeting.
Sure. Well, the first initial intake is basically like a free consultation. You come in and meet with an attorney here. You explain how the accident occurred. We ask you several questions. When. Where were you coming from? Where were you going? All of the initial facts, and then we ask you follow-up questions about your medical treatment. Now, I just said free consultation, but But actually here we work on a contingency fee basis. And what does that mean? It means that there are no out-of-pocket expenses. It's only if we can reach a resolution, a settlement, or a judgment for your claim that we actually get compensated.
So there is no out-of-pocket expenses for an individual that seeks our legal services, and the contingency is at the end. That is how the legal fee works.
That's correct. The legal fee only gets taken out, as I mentioned, if we are successful with coming to a resolution, settling a case, reaching a judgment, in court. We take out our fee, which is 1/3. If we are unable to be successful with the claim, the plaintiff will not have any out-of-pocket expenses, and nothing will be paid at the end by them.
I just want to use a moment just to highlight one of the features that we're very proud of, and that is our mobile law office program. We have 3 mobile law offices, and suggest that someone, if you're interested, take a look at our mobile office program, which is on our website, which is www.dearielaw.com. And we are very happy when an individual, not that they're injured, but if they're injured and they're unable to travel to one of our 4 regular offices, our mobile office can drive to their community, or as we like to say, right to your doorstep at no extra cost, the attorney and other legal assistance that we can provide. So keep that in the back of your mind. Are very, very effective, I believe, and very helpful, and something we're enormously proud of is that's our mobile office program. Lindsay, appreciate it very much. Lindsay Harriman, and I hope that you have found this not only to be informative, most importantly, but also helpful. Thanks very much for watching Face to Face.
Thank you.